The Supreme Court this morning visits an unfamiliar subject, social media. The justices will hear arguments over how to define a criminal threat online. Their ruling, expected next year, could set an important precedent. Jan Crawford is at the Supreme Court with this high-tech battle over safety and free speech. Jan, good morning.
Well, good morning. So the court is taking up the case of Anthony Alonis. He claimed to be an aspiring rapper, so he could post these violent lyrics and messages on Facebook about his former wife who had left him a few months earlier. Now, he says that he never intended to act on these words, and that's why they should not be considered threats.
I don't remember how they got there, but I guess I must have killed them.
With heroes like this, and a sense of humor like this.
I want to kill the President of the United States of America. I'm not actually saying it. I'm just letting you know that it's illegal to say that.
Anthony Alonis wrote post after post on Facebook, describing ways he could hurt his former wife and members of his community. In one post he wrote, "I'm not gonna rest until your body is a mess, soaked in blood and dying from all the little cuts. Hurry up and die." Another signaled thoughts of shooting up a school. Enough elementary schools in a 10-mile radius to initiate the most heinous school shooting ever imagined, and hell hath no fury like a crazy man in a kindergarten class. But are those words on Facebook a crime, or just rants on the internet? Alonis' lawyer, John Elwood, said the court should look at whether his client really intended harm.
You know, you can hear this stuff on the radio any day of the week. And the point of it is that, you know, just because you say it doesn't mean it's meant literally.
Alonis was convicted for making threats and sentenced to prison. He wants the court to throw out his conviction, arguing his posts were free speech protected by the First Amendment. It's a cutting-edge case, focusing on speech online where people often push the envelope, but the ruling would also apply to more traditional forms of communication. In past cases, the court has sided with free speech, ruling in 2003, for example, that cross-burning can sometimes be protected under the Constitution and isn't necessarily a true threat. But domestic violence advocates are urging the court in this case to draw the line and not allow people like Alonis to go unpunished for threatening language.
Threats are not merely words, and it's not true that sticks and stones can break my bones, but words can never hurt me. Threats like that are terrorizing.
Now, domestic violence advocates say that a ruling for Alonis could give abusers a free pass to post these threats on Facebook and then just claim it's free speech. But the other side says cracking down on free speech in this kind of case would have broad implications, especially for young people who tend to post things, blog, tweet, all kind of stuff, and not really realize how it could be interpreted. Gail?
Maybe people start thinking about it. Thank you,
Jan, before you go on a non-judicial matter, what happened between Auburn and Alabama?
You know, the tide rolled just as we expected, and now we're headed to the SEC championship and then the national championship, and roll tide and go SEC.
Revenge is sweet, is it not?
Absolutely.
Thank you for clearing that up, Jan.
Thank you, Jan.
I got my red on too, guys.
I
Roll
noticed.
Tide.
We noticed your red. Looks good. Looks
Always good to see you.
Thank you.